All right. Thank you, Christoph, for inviting me here. Thank you very much, everyone, for coming. I hope this subject is, even though we've spent so much time already today, is still of interest to you. You might ask yourself, why bankruptcy, why insolvency, why is this even relevant? Usually, most people in commerce or lawyers don't like to think about this, but we also don't like to think about death, but it's still there. And even when I studied law, I didn't do bankruptcy law at all, but even in civil, in the normal classes in the civil code, there was always the question, who in a way has to bear the insolvency risk? Nobody knew what that was, but that was always the question. So when we do commerce, when we interact with transactions, there's always the looming bankruptcy insolvency risk in the back. And why not have a look at this? Because you cannot avoid it anyhow, but maybe you can, by knowing what is there, do something about it, or at least know what you're facing, especially in this space as well. Okay, digital assets in insolvency, when blockchains meet bankruptcy, and let me tell you, they're probably going to meet. Right? We have, as everyone knows, a lot of crypto financings going on, initial coin offerings and so forth, sometimes with questionable business models or no business models. People are collecting assets, things of value, which is interesting for a bankruptcy practitioner, because when there is value, you want to preserve value. And we'll see how this is going to be handled. In a way, there's currently a bubble growing, and it will probably burst, and then let's see whether this can be handled in an effective way. So, Christoph, please correct me if I get this totally wrong, because I'm just a simple legal practitioner, not a law professor, but in a way, you can have an ideal of bankruptcy law. Maybe you don't want to face it, and especially if you are the bankrupt or insolvent person or entity. However, why do we even have this? Well, back in the day, people were just thrown into the tower of debt and left to die or to be paid out by their family and rescued. Nowadays, we have more modern ways of dealing with this in any modern jurisdiction. This is, in a way, a general overview. We don't want to have a race to the courthouse. If people realize the company is failing, back in the day, everybody would just race there, get the machinery out, which would just destroy an ongoing business and was not effective. So we don't want to have a race to the courthouse. That's why we want to have procedures where, in case there's a crisis that leads to a just resolution, we want equal treatment of creditors, creditor equality. We want to preserve value in assets. Famous cases in the US in the 19th century, they built a big train tracks all over the US. Then after 20 years, the train companies failed. Under the old paradigm, you would have sold the locomotives and the tracks for scrap, with no train tracks, then going from New York to Ohio and then to California. And then people realized maybe we can leave the assets actually in place and just kick out the old creditors or kick out the old shareholders and restructure and reorganize with a fresh start. So sometimes not liquidating and selling something for scrap is actually, makes a great deal of sense for the company, also for the employees, for the business, and maybe for society in general. You want to have a financial and operative restructuring and reorganization. Maybe a company has just too much debt, then you might want to cancel the debt. Maybe a company is just selling stuff that no one wants. Then just canceling the debt is not going to help, because they still will create stuff that no one wants. So you can have a look at that. You want to maybe have a fresh start for a company, a discharge of debt. And one difference between bankruptcy and insolvency law, I think that the insolvency law would be the European approach. Only if you are not able to pay your debt, you're insolvent, and then you can restructure. The US approach would be whenever you think your debt burden is too big, you try to resolve it, even though you're technically still able to pay your debts. I mean, there were some famous cases in the US where a company would be insolvent in 20 years because of the asbestos litigation, and they just decided, we don't want to go bankrupt in 20 years, let's just cancel the debt now. Okay, so that's there. It's in a way a pliable, a set of tools that's pliable. You can do many things depending on the jurisdictions. And the question is, do these tools that are there for a good reason work in this new environment of unstoppable, immutable blockchains and smart contracts? What we don't want to do, we don't just want to punish a debtor. Economic failure is not itself a crime. It's not. Can be under other circumstances. It's a learning experience. But what if you cannot learn because everything you've created is totally stuck in software that is a digital ruin and you cannot restructure? That's not great, then you cannot really use what you've learned. Okay, what is a blockchain? At least for BaFin, I'm a lawyer, so I like definitions, right? So, and I've some friends of mine, they have an issue with this. Florian told me today that he has an issue with this definition, but I mean, it's the German financial regulator. If they throw out a definition, let's take it serious, okay? So blockchains are tamper-proof, distributed data structures in which transactions are recorded in chronological order and mapped in an understandable and unalterable form without any centralized control. Blockchain technology makes it possible to save and manage ownership more directly and efficiently than before because it works on the basis of uninterrupted and unalterable data recording. Save and manage ownership. Oh, that's when the bankruptcy practitioners, they prick their ears, because that's in a way very often what is important. Where are the assets? Who owns them? If the company or the in bankruptcy, if you can get a hold of it, can you dispose of them for a certain price? What can you do with them? And then you're in a way making, you're encountering this, it's more directly and efficiently. That sounds in a way great. Maybe we can restructure even better if we have everything in a digital ledger that allows us to move things around much quicker, right? One example would be like under German law, shares in a company, they can be pledged, encumbered as security, but try to enforce that really. You have to go to a notary, you have to sell them at an auction. Wouldn't it be nicer if this was all done by modern software? Another thing is, it says here tamper-proof. We didn't talk so much about this, but during the break I talked with Anurus Tashiro and with Pia about this. When the BaFin or other people from the scene say the blockchain is tamper-proof, that might be true from this perspective of software engineers and information technology, but we do not have any case law worldwide. I sometimes ask people everywhere, do we have a case where court said what is in this blockchain is actually proven? It's probably not going to happen for a while, because you probably, in a German court at least, you would have to print out the whole Bitcoin blockchain or the whole Ethereum blockchain, put it there, deliver it in a truck, because the judges will not look at it online. Like you can't just show them, I don't know, the Mist browser or something and say, this is where it is. And then probably an expert will have to opine on this. But be that as it may, as an introduction. Now, in bankruptcy and insolvency, you deal with risks and with failure. Now, interestingly enough, even the most popular blockchain that is able to run smart contracts, the Ethereum blockchain, apparently is by itself a risky business. It's, when you look under ethereum.org/agreement, you see that, at least from the perspective of the Ethereum Foundation and Swiss Foundation, you're entering into a contract with Ethereum when you interact on Ethereum. You might disagree with this, but and even with arbitration. So if you have an issue with the Ethereum Foundation, they take you to arbitration, actually. But in this agreement, they tell you how risky it is currently to interact on this. And I think everybody who does anything of value with many people involved on the Ethereum blockchain should be mindful that they're running an experiment, which is fine. I mean, it's great to be an entrepreneur and, in a way, run risk like the people who started the DAO in 2016, they just did it, right? And here also people do it, and I think that's in a way to be welcomed if you at least protect vulnerable people. But be aware, cryptography is an art, not a science, they say. I'm not really sure what they mean by this, but apparently it means that's an art. Maybe we can change the rules, and maybe it's not so reliable, or it can mean whatever you want it to mean. Right? They say advances in code cracking or technical advances such as the development of quantum computers could present risks to cryptocurrencies and the Ethereum platform, which could result in the theft or loss of Ether, the currency. So you're running this on a, imagine that, I don't know, Microsoft told you, you can write all of these nice documents here, but they can vanish any day. It's like, maybe you don't want this, but maybe if that's the best you have, and we're still in a trial stage, that's what it is. But that's if you have a business model running in this space, that's the shaky platform you're operating on, okay? And even going forward, because they're still working on this and improving it, they might introduce weaknesses or bugs into the core infrastructure elements, right? Fair enough, can happen. So but that's just in a way as a general warning what this is running on. And as I said, Ethereum or any derivatives of it is the place to go if you want to run something more complicated in this space. Okay. Bankruptcy versus blockchain. Anybody has a question or wants to interrupt me, please feel free to do so. And I'm presuming certain knowledge, like what the DAO was in 2016, this famous decentralized autonomous organization as an investment fund that in a way was so huge and loomed, it was all over the news, and then had this hack or non-hack, depending on what you think, and the question what it really was. One of the challenges is the application of national fragmented insolvency law to transnational crypto assets issues and multi-jurisdictional challenges. It's in a way very specified already. You could argue before, as we did today, where are any DAOs or an ICO, where are things? I have friends from Ethereum or people who actually started the DAO. I mean, they say they didn't start it. They just coded it and put it out there and somebody then deployed it. It wasn't them. Of course, it was them. Anyhow, the question, and you sometimes hear this argument, oh, it's so complicated, it's everywhere, right? It's in the blockchain somewhere, and that's why no law applies. And my answer is always, that's probably why every law in the world applies, and you're bound by 200, I don't know, Christoph, how many jurisdictions do we currently have in the world? Over 200. So maybe then you have this jurisdictional overload, and you have to comply with the securities law of the US and Liechtenstein and Germany and Malta and what have you. Maybe that's not fun. However, that's not something new. That's what you face in other issues as well. When you have investors from all over the world investing in an asset, people have their domiciles somewhere, and that might mean that their local laws apply to tax issues. So it's not new that if you are in international commerce that many laws apply and that these laws might not fit. However, with the DAO, for instance, it was clear it was deployed by people from Switzerland and Germany. It was not so clear where all the investors were, but if arguably this was a German limited, not a limited, but a company under German civil law, Gesellschaft bürgerlichen Rechts, that would have meant that anybody who participated in it would have been liable in full personally under Section 120U of the German Commercial Code, analogous application. And if that company then, because of the software hack, in that case they hadn't agreed to fund anything yet, but if they had done so and then had in a way obligated themselves to fund something, and then because of the hack they couldn't, they would have maybe been technically insolvent under German law, and then everybody in this company, the 17,000 people, had the obligation to file for insolvency, and otherwise they would have committed a crime. And people then again say, oh, but it's nowhere. To which I always say, well, a German court or any other court will, if they look at this, it could happen that they find that they have jurisdiction. It's like we discussed this, the famous Niki case, right, the Niki airline, where a German court says the center of main interest is in Germany, an Austrian court says, no, it's in Austria. You have European rules in place that actually should prevent this from happening. Courts disagreeing on this, still happens. This will probably also happen in this case, and it's not going to go away. You can't just say, la, 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 it's all over the world. No one will find that a court has jurisdictions. Courts will probably find jurisdiction. Maybe they're wrong, but then they still find that they're in charge, and that you have to appear. If you don't appear, you might lose without even having had your day in court, right? So, and if you have bankruptcy law apply, then you have legal principles like in the US, you have the automatic stay. If you file for bankruptcy, everything in a way is stopped. Under German law, you have clauses that say if you file for bankruptcy, others cannot just terminate your contracts. What do you do if you people, you see this in practice all the time. In contracts, there are clauses that say, oh, if this entity files for insolvency, everything is canceled. It's illegal under German law, or let's say it's invalid. Same under US law, arguably sometimes also under British law and other jurisdictions. What do you do if that's what the law says, but the way the contracts, the coded contracts operate, they ignore this, and the assets are just returned, and you cannot really get them back. Of course, you would say just because someone is not observing the law, that does not negate the law. This happens all the time in other cases as well. But it might be a new issue here if people don't program things so pliable or so much in compliance with the law, and then they have to think of these rules. Next thing and that's going to probably be one of the big issues from 2018 on for insolvency practitioners. How do you find these digital assets? I mean, we had these questions today, like if currencies or if the cryptocurrency is sent to a smart contract, or you only have these addresses, how do you even determine who owns something? Can you have, are digital assets, are cryptocurrencies in a way, can they be owned? We all know they have some value. So, for instance, on the German constitutional law, if they have value, they're in a way, in a constitutional sense, property. We do not have a resolution as to they're probably not real property because you can't touch them. So under section 90 of the German Commercial Code, they're not tangible, so they're just something. And then the question is, if that is so, is this just an issue? If, for instance, a company has collected a lot of funds via an ICO, and then their business model doesn't work, they spend a lot of the funds coming in on Lamborghinis, that's one of the typical examples, people spend it, they still have some left, the insolvency administrator comes in, and then they find that they had access to funds, right? Or you see people on their smartphones, in their wallets, whatever, there is this. But how do you, in a way, sort out to whom it belongs? You could, if you come in as an administrator of a company, you might see that there are access rights to certain assets, but maybe the managing directors will argue that that's their private stuff, right? And how do you separate this? It's not just an issue of forensics. Of course, you might, in a way, not know that a certain debtor has crypto assets of a considerable value, and that you might have to find out by checking the IT structure you have there. But even then, it might be tricky. Then you might have something, but you're not really sure whether you can dispose of it, and that will be an issue. Next thing that's also going to happen, we just had a case in Hessen where in a criminal case, 2 years ago, I think they from some person in a criminal activity, I don't know, was it maybe drugs or something, at least the police got hold of a few bitcoins that were back then, I think, valued at 19,000 euros. They didn't know what to do with it. They held onto it. Now they're worth 2 million. And the question was, can they sell them? Now, you would argue if the police finds cocaine, which is also worth a lot, they can't just say, well, you know, it's worth it, let's just sell it. No. Of course, we would not initially say per se that bitcoins are in a way a tainted or illegal asset. No, we have no decision on this. Nobody's made this case. The European Court of Justice even found that if you change bitcoins into something else, you don't have to pay VAT. They wouldn't have found this for an asset that is by itself illegal. But there could be issues like anti-money laundering, or if you do Bitcoin trading to a certain degree that you have from a certain amount of value on that, you have to have a permit from BaFin. What do you do as an insolvency administrator if you come across this? You see there's something of value, and you know Bitcoin, the exchange rate or the value of it is fluctuating wildly, and then if you are afraid of it, to dispose of it, then the creditors might say, well, you had bitcoins that were worth 2 million yesterday, now everything crashes, it's just worth 2 cents. You're liable as an insolvency administrator or as a liquidator. You don't want that, so you want to sell this. What they did in Hessen, I believe, is they sold it as a verderbliches Gut, how you say that, as if it was something that would, in a way, soon wither away. Because of the volatility, of course, bitcoins don't get bad, right? They don't get moldy, and as long as the computers are there, they're always fresh and pristine. But of course, the exchange rate or the value might change, and that's why they were, in their mind, able to sell it. They just did it. Of course, they did it. And then the question is, will this ever be reviewed by a court? But you will come across issues like this. Okay. We talked a lot about smart contracts, so I don't want to go through all of these definitions. Why are smart contracts also in this context relevant? Marcus addressed this to a large degree. Smart contracts, in a way, they're running automatically as far as possible, as far as you can automatize things. And that sounds great, but it could also pose problems when actually by law, you want to stop the execution of a contract, which is easy for a so-called paper contract, because you just don't do it, you just don't act. But what do you do if the contract marches on? That was the problem, for instance, with the famous DAO. They had it on their website, code is law, and the DAO is run by unstoppable and immutable code. To which I say, can law be unstoppable and immutable? Isn't that in a way something that law is not about, except for divine law, like natural law or Sharia law, anything, any holy law? You could argue that's in a way you cannot change it. Of course, people would interpret it in a different way. But normal human-made law, at least since positivism in a way has been instated, is actually changeable. It's in a way a paradox. Law is supposed to give you stability, clarity, in a way, make you able to look in the future, but actually in practice you find that laws are changed all the time. Your expectations are thwarted. It's either the law is changed or the case law changes, so law is really actually not stable, not very stable. Famous case with the German Insolvency Act, Insolvency Code, enacted in 1994, in force since 1999, and since then it's been changed every year. It's almost well, you can still recognize it, but this law is in a way all crumbling on all these changes, and it didn't last very long, and maybe it will eventually be replaced. So law is always changing, and that's great, because sometimes you might realize the laws that we have in place are not great. So you change them. But what do you do if you have coded something that is governing a social organization like a company and you cannot change it? Then in a way you have to get it right in the beginning. It's very unlikely that people get it right in the beginning. You know this old saying, I think by Churchill, about the Americans. Americans always get it right after having tried out every other option, right? So, and maybe that's a good approach. You try, you fail, right? But in this system, you just might fail, and that's it, because you can't rectify it. That's not great, right? Okay, but maybe that's what we have to deal with. Exactly, so even BaFin, this is from the BaFin, the second bullet there, risks associated with smart contracts primarily have to do with the lack of a central entity which can take corrective action against any intentional or unintentional misconduct, to which people from the blockchain scene would say that's not a bug, that's a feature. That's what we want. We do not want a central entity that is changing it. That's, in a way, is an entry door for corruption and what have you. Fair point, okay? But then you better get it right in the beginning, which you probably can't. Anyhow, so how can loss of value be avoided if a smart contract does not fit anymore, but is immutable and unstoppable? I call this the Sorcerers Apprentice dilemma. Instead of Besen, please insert smart contract, right? Ein verruchter Besen, der nicht hören will. A horrible smart contract that is not listening to me. Herr, die Not ist groß, die ich rief, die Geister werde ich nun nicht los. I mean, it's the ghosts I summoned, the smart contracts I summoned, I can't get rid of anymore, right? It's like, and you might have then something that is still ticking and going, and is just a digital ruin, and you might just have to let it be. Like what they, in a way, did with the DAO, essentially, they did this hard fork on Ethereum and resolved that, and it's sitting there. And as a failed experiment. I'm not saying this in a negative way. Just how much time? What time do I have, Christoph? 7 minutes. Oh my God. Oh my God. So are smart contracts programmed flexibly enough to cope with new economic situations? The question, if I ask like this, probably you would say, yeah, if you do it, but people will have to do it. It's a learning experience, right? As always with software. So that's probably what will have to happen. People might probably create better libraries. That's why I also asked this question to Markus. Why shouldn't we, in a way, learn from case decisions where we realize a certain smart contract is not ideal, it needs to be improved? Wouldn't that be great if this is published? Because then after a certain time you can agree on public libraries where smart contracts for certain consumer situations are there and everybody agrees, maybe with an approval stamp from an authority. That's a good version that works well. And that's probably what has to happen. But before you will encounter things where things go wrong and then are just stuck. Specific problem under German law, but I'm pretty sure this also exists under other laws as well. Again, the famous, I don't know, this case with the damage payments that are in a way paid by the airline the moment the airplane is touching ground and is too late. What do if, for instance, Air Berlin was flying while insolvent under German law, as a managing director of a company that is subject to German law, and Air Berlin was subject, even though it was a PLC, under British law, because it had the center of main interest in Germany. And the European Court of Justice found that even this provision applies to a British company operating in Germany. What this provision, 64 GmbH, says, and similar provisions say, if you are insolvent, you're only allowed to make payments that are really necessary in due course for the, how do you say this, if you are Sorgfalt eines ordentlichen Geschäftsmanns, if you are using if you are as careful as a regular business person, and that usually means that you cannot make many payments. And the sanction is heavy because it's a personal liability. If you imagine that all the airplanes of Air Berlin, while Air Berlin is insolvent, land, and the smart contracts are happily handing out all the damages payments because there's still enough liquidity there, let's say like this. And they do this for 2 or 3 days, and then you realize, no, they were insolvent. It was not proper to pay this out. They should have preserved their liquidity, and the management of Air Berlin is now personally liable, I don't know, for 30 million euros. They would not like that, right? They would say, no, that was the smart contract, stupid smart contract. We didn't stop it. We had to think of other things, right? And you could argue, well, if the smart contract really cannot be stopped because of a program like this, then maybe, like the German, it's impossible, right? How do you say it in Latin? Impossibili? No, if you're not obligated if something is impossible, right? But you could, of course, say, well, that if they programmed it in such a crappy way, maybe they are liable. And then the question is, intent is sometimes relevant. Whose intent counts? And I always like, in this situation as a German lawyer, like to quote a very famous, I think in my mind, famous decision by the German Federal Court of Justice from 4 years ago. And I know I have not much time, but that's a decision that's dear to me, because very often people in this space when it comes to blockchain say that, I mean, cars are paying cars, or smart contracts are paying smart contracts. People anthropomorphize these things, whereas actually, for instance, on the German law, it's still humans acting, maybe as a fiction. German case law by the Federal Court of Justice on who's actually, whose intent counts. Maybe first read it in German, then in my own translation. Für die Auslegung von Erklärungen ist aber nicht auf die automatisierte Reaktion des Computersystems abzustellen. Nicht das Computersystem, sondern die Person oder das Unternehmen, die es als Kommunikationsmittel nutzt, gibt die Erklärung ab oder ist Empfänger der abgegebenen Erklärung. Der Inhalt der Erklärung ist mithin nicht danach zu bestimmen, wie sie das automatisierte System voraussichtlich deuten und verarbeiten wird, sondern danach, wie sie der menschliche Adressat nach treuem Glauben und der Verkehrssitte verstehen darf. English? It does not depend on the view of the software or the developer. For the interpretation of declarations, it's not possible to rely on the automated reaction of the computer system, which reminds me of smart contracts. Not the computer, but the person that uses it as a means of communication is issuing the declaration as the recipient of the declaration made. Content of the declaration is therefore not to be determined in accordance with how it is expected to be interpreted and processed by the automated system, but rather according to the way in which the human addressee may understand it. What happened in that case was somebody wanted to fly with a partner somewhere, did not know yet with whom, so booked a flight for him or herself personally, and in the automatic booking system on the website just inserted name will be presented later, Name unbekannt. That's what they put in there. And the booking system accepted that, because the booking system cannot understand if the last name is Braegelmann or the last name is name not known or name to be determined later, right? So that person got a confirmation via email that the contract was actually concluded, and then he later came to the airline and said, well, now I know who's going to fly with me. And they said, you can't change the name, and you don't even have a contract. And that person said, well, this computer system gave me a declaration that the contract was concluded, to which the Federal Court of Justice said, no, you fooled the computer system, no contract there. And I think that's currently what we have in Germany, and that's what you have to keep in mind when we talk about interactions of smart contracts in the system. We will always have to go back to the intent of the people doing these, and that might be tricky to find out. So, I know I'm running out of time. Maybe one important thing, last year the European Union had a consultation on the digitization of European law, and as we heard yesterday in these talks about the new German government, they also addressed the issue of digitization of company law. That might be exciting because company law, especially in Germany, is very outmoded or slow. Like, I mean, when you want to issue, if you want to acquire shares in the company, you have to go to a notary. That takes time. If you want to encumber shares, if you want to register things. And the European Union, in its consultation last year, asked a question whether it should not be possible to put shareholder votes in shares on a blockchain solution. Right? In Delaware, I think they enacted a law where they already allow this, where you can register shares on a kind of blockchain. And if the European Union is now looking into this, and maybe they just threw in this word because you can throw in blockchain anywhere. Long Island Iced Tea renamed itself, I think, blockchain something. Kodak is issuing a Kodak coin. Maybe it's just a buzzword, but maybe not. And that would be exciting if, for instance, company law is digitized in this way, with these problems that I addressed earlier. Then how do you restructure a company if shares are on a blockchain, which is supposed to be make everything easier, but maybe not because things are not programmed well, right? Maybe one of the last slides, bankruptcy. Before I always talked about the mismatch, but maybe things can also be beneficial. Can we use this in the scenario for good? Can we? If people act in this space, maybe we can also restructure them in this space. Maybe if we have a company that is run on a blockchain and is dealing with cryptocurrencies and is failing because of a lack of funds, of a misguided business model, maybe we can have a plan of reorganization also as a smart contract, maybe even under German law. Doesn't need to be notarized. So maybe we could have this. Would be interesting to find this out. Maybe here, Florian or Frau Tashiru, maybe you could, in a way, come up with an insolvency plan as a smart contract. That would be nice. Or other ways to, in a way, when you restructure, you sometimes hand out new shares in companies, and maybe you do this on this as well. Last slide, I think. What happens to the principles that I addressed in the beginning? We don't want to have a race to the courthouse. Do we even have a courthouse, right? I mean, maybe we're, as people sometimes say, we're totally above the laws, but I think there will be a courthouse. Equal treatment of creditors. That's one of the core principles. What happens if the way things are programmed, this is not possible? If people have built-in preferences that you cannot break, because if you do something, the smart contracts will realize it, because you trigger some oracles like external information that goes in there. What do you do then? How do you preserve value? Will you deal with digital ruins that you just have to leave alone and let smolder? Fresh start. Is this all going to be possible? And then the very, very last slide, maybe we need a new paradigm. One of the paradigms is always fresh start, restructuring, everything. But if this is not possible, or it might be difficult, maybe we need something new. Maybe if we're dealing with a new world here, maybe to have, in a way, the ideals of bankruptcy law reinstated, you need some kind of new digital identity. You fail, and you set up newly in this space. Wouldn't that be interesting? Other ideas? I think that ends my talk. I thank you for your patience. Thank you.
Needless to point out that I found this extremely interesting, and no big surprise. Anna Rose is the first one who's going to ask. It's here. Anybody?
Thank you. To some extent, in response to some of your remarks, but in a way, a question without expecting an answer, to be honest. The problem about the evaluate or the changing value of bitcoins in insolvency, and the question how to actually deal with that later on had arisen in the Mt. Gox insolvency in Japan. That company, for those who are not familiar, it's an exchange.
Put it closer.
It's an exchange platform, basically, an exchange platform for bitcoins, and I think one of the first ones. And they fell into insolvency in 2012 after, I don't remember, 800,000 bitcoins went somewhere. And they, so all of those people who were using that platform for trading and exchanging bitcoins lost their entire value. So they have filed their proof of claim in the Japanese insolvency proceedings, with the result that at that time, for I think about $400 per Bitcoin, their original claim or their original property and value for bitcoins was exchanged into Japanese yen on the exchange rate of, at that time, 1 bitcoin, $400. Now, the insolvency administrator found, however you found, lost bitcoins, but he found about 200,000 bitcoins back.
Nice.
Into the insolvency engine. Exactly right. But the problem is that now the bitcoins have risen to about 15,000 US dollars per bitcoin, and and all the claims have been exchanged to Japanese yen already, and there's no chance to pay out those bitcoins anymore. So the Japanese insolvency administrator is sitting on this huge amount of money in bitcoins, but he, because of how the insolvency law works, needs to pay out in Japanese yen, which has been exchanged and determined 5 years ago for about a fraction of the value that it is now.
Yeah, it's a fascinating. I heard about this. In a way, technically, Mt. Gox is not insolvent anymore because
exactly right.
Right.
Exactly.
So in a way, they could just lift the proceedings, and he sells off the bitcoins, and everybody's happy. But that's probably not going to happen.
So to your point, I mean, if there's a chance to say for cases like this, you would draw up an insolvency plan that allows you to pay back in bitcoins as opposed to yen or euro or whatever.
Right.
That could have been the solution.
That could work. Bitcoin is in a way tricky because it was meant as a means of payment, and now it's a store of value, and it doesn't work so well. Maybe as soon as the European Central Bank creates some kind of crypto euro that is not fluctuating in value or only is fluctuating in exchange to other things, then you have taken care of this issue. Because in a way, it's a funny issue, but it could happen with other assets as well. I mean, it's not Bitcoin specific. You could sit on other assets that are suddenly valuable, and so it's in a way maybe not even the case that is so specific for this.
Couldn't they have made an insolvency plan and then agree on a different currency?
Well, the issue is that the
Hold it closer.
when they determined and allowed all the claims in the proceedings, they exchanged into Japanese yen 5 years ago for a tenth or even more, well, less, of the fraction. So these people have now an allowed claim for just a fraction. And if the bitcoins would have stayed there, and if it would not have been exchanged, they would have a huge, and they could get back their payment and their dividends in bitcoins as opposed to Japanese yen. The value would be 100 times as have been at the time.
Which is interesting also for the Aktie Pauliana.
Exactly.
I mean, that's killing.
Yes.
That's killing when you are receiving bitcoins and you have to repay the value which it has today.
Right. But then old German case law from the Reichsgericht, die Aufwertungsentscheidung, you know, this kind of stuff where they will then recharacterize contracts because nobody was expecting such a price swing.
But what do you do with all the money now? Pay it back to the fraudster.
Thanks for your talk. But I've got a question. You were always referring to smart contracts as being unstoppable.
Yes.
But from my point of view, it's not a problem to include some kind of kill switch. For
Yes.
example, special transactions sent from a wallet.
Absolutely.
And so then you could stop a smart contract. So
If it's built in before.
yeah, of course. But I
But
mean,
the great
it's
thing
super
about the
easy to build.
human contract is, like, I don't know, some shareholder agreement or what have you, you don't have to build this in. If you realize it's crap or something is wrong, you just say, well, that's not what we meant, let's not do this, right? So there, with legal contracts, in a way, Marcus dealt with this before, the word smart contract is misleading. In a way, smart contracts are just facts. I have an example for smart. For instance, the difference between a contract and a smart contract. We're both on a hill, and I have a piece of gold, and I promise to you that once we're both walking down the mountain, I will give you the gold, this big ball of gold at the restaurant where we meet downstairs in the mountains, right? And then in a contract scenario, we would agree on this, and we both walk down the hill, and then in the restaurant, I give you the piece of gold. But smart contract is different. We say that I do this, and then I roll this ball of gold down the hill, right? And it rolls by itself, and it's unstoppable, and it probably hits the restaurant. And maybe I'm not making myself fully clear, but in a way, it's just factually delivered there, and you cannot stop it. And that's different from a legal agreement where you promise something, and let's see if you deliver on that promise. And because you don't know if that promise is fulfilled, you can always change it. And smart contracts are different. And then you can do this, but you better do this. And as you saw, some people don't like this idea that it is changeable because it opens yourself up to governmental intervention, and part of this whole space is created as, I shouldn't say anti-governmental, idea, but in a way non-governmental way of interacting.
Exactly.
Okay?
I'm not an expert for blockchain or insolvency law, but just from what I learned yesterday and today, isn't there just a simple situation where you can steal from your creditors just by when the managing directors transfer the bitcoins to an address, and you as an insolvency administrator cannot challenge this legal action because you don't know who's the owner of this address?
Or even if you know you cannot get it back because it's gone.
Exactly, and maybe after 2 years in prison he can exchange this bitcoin to real money in whatever exchange, but how far the German insolvency ordinance or the European insolvency regulation should be altered immediately in order to prevent such cases?
I don't think you have to alter it. You have always, in a way, replacement of value, of Deutsch Wertersatz, in a way. If somebody cannot deliver in kind, if I have cash and I give it to someone and in violation of insolvency law because I was already insolvent and you in a way would contest that, then maybe if the asset is still there, you can bring it back. If this is not possible factually because it's not built like this, then the other party has to in a way pay the equivalent in way value and might even be personally liable, right? So I think the court system is, or the way these claims would work are already there, because if you cannot return the asset, like if the digital asset, whatever it is gone and you cannot unwind it, then and if you know who is liable, of course, that you have to find out, but that's in a way a factual issue, not a legal issue. If you know who would be liable, and if they then say they cannot bring back this specific asset, then you can say, well, then restitute the value. And then you can argue which value. Would it be the Bitcoin for 400 euros or for 20,000 euros? Okay. But that's a factual question.
Matthias and then Michael.
Thank you for the presentation. A lot of real important questions, to most of which I don't have an answer as well. But just want to come back to the idea of
Can I make a short interruption? He is an expert in this topic as well. He has written a fantastic article in NZE 17, page 1, on digital assets.
Just I will come back to the idea of a kill switch.
I mean, be happy. You should smile.
Of course I do. No, the question is whether there may be even compliance reasons for businesses not to enter into smart contract without such a kill switch. And I want to come back to your Air Berlin example. As you may be aware, after Air Berlin shut down, the prices demanded by Lufthansa just went up through the roof, which of course brought the Federal Cartel Office in place. And Lufthansa was pretty surprised. They argued, oh, we didn't see that coming. It was the algorithms, it wasn't our fault. And the Cartel Office said, okay, but you're responsible for the algorithms that they are using. And I think the same logic might be applied when it comes to smart contracts, which have no mechanism in place for insolvency, which then might trigger personal liability of the stakeholder.
People very often haven't thought about that they might be personally liable if things go wrong. And as soon as this reality sinks more in, then people will probably be more careful as in other things. Oh, that's good. Anyone else? Yeah.
Yeah, Michael Schilling. He's from the King's College. He's doing something.
Thanks very much. Very interesting again. I was wondering whether you could say a little bit or maybe speculate about what the balance sheet of an insolvent DAO would look like. Because it's difficult for me to see how something like that could be insolvent. Because on the asset side, of course, you would have the ether, and after the theft, there would be much less ether there.
Yeah.
But on the basis of the way the tokens were issued and sold, I mean, I'm not entirely sure what would be on the liability side of that, entity or whatever it is.
In that specific case with that DAO, I mean, Christoph Jensch and the others from Slocket, they created it because they couldn't get venture capital funding, so they decided, let's create our own venture capital funding. Let's create a decentralized autonomous organization that's collecting funds and then would fund certain projects. And they did not get to this stage where people would have voted. As we found out yesterday, only 20% of the people who could vote. So it was stuck. But imagine that this organization did not have this hard fork issue, did not have the hacking, but actually by a vote agreed on funding something, right? in a way, then if you argue that this DAO is a legal entity, then in a way obligating it maybe itself to pay out something, right? To a contractor who builds some kind of software, something. And imagine that then they fail, right? And then they're obligated to pay. In this case, they just collected money, and they did not create any obligation. They didn't enter into any contract to serve the money. And then, of course, the question was also, do they maybe have to pay it back to everyone else? But only in that scenario when they're really over-indebted and have obligations. And then the question was beforehand, is there really a legal entity that has an obligation? Because I would only make an argument they probably created some kind of legal entity somewhere, but maybe not. Maybe it was just some factual collection of value, and there was no legal entity where then you don't have an insolvency issue because you have no debtor.
Yeah, I think you're right. I mean, if they have already committed the funds to certain projects,
Yes.
sort of, then you can see a liability
Yes.
structure. But as far as I understand, the tokens do not entail sort of a cash flow or payout structure in themselves.
No, that's true, yeah.
And then, you know, you could think of unjust enrichment if the whole thing breaks down or whatever. But then again, you know, if, say, the value of Ether would drop in the meantime so that I couldn't do what I wanted to do initially. So again, it seems to me that you could even almost read a condition into the sort of contract or whatever it is by signing up for this, investors signing up for this, that they must actually be able to or actually have the funds to then go about this. So which again would sort of cut off the insolvency problem at this stage.
But a comparison would be you found a GmbH, people put in capital, but they're not doing anything, right? In a way, then they have money. How can they be insolvent? I mean, they have no debt, right? And in that case, the DAO just didn't have any liabilities, right? But, I mean, as these are supposed to be business entities to fund things, or not only fund things, but to be in business, there will be situations where whatever they do fails, business models fail. We know that people not only fail because of fraud or something, the business models fail, people spend the money they had, and then they have to liquidate, and sometimes people liquidate too late, and that could happen in this scenario as well. But there's so many questions before to resolve. Is there even legally a debtor in that sense? And if there is, where is it? Under what law? And where's the COMI and all this? And you could still nowadays, because we have no case law, make the case there is no legal entity. This is just a factual gathering of people who pool some value to fund things, and then maybe they're all individually funded. There's no middle entity. I don't know. But these questions will arise, and poor insolvency judge who will have to deal with it.
Absolutely. In this context, forgive me, entirely different question. It doesn't fit really into your topic, well, only to a certain degree. And I don't have a solution to that, and I have to speak about it in a week in Texas. There is a debtor in the case of Venezuela. In Venezuela, Maduro is creating, in order to get out, they are insolvent. They are definitely insolvent. They have already years ago started to give futures as security, which means that they are broke. They are definitely broke. Nevertheless, they are now creating a cryptocurrency called Petro, and it is meant to be, it's announced to be secured by the oil, which is already given away in the futures. And is this a rescue mechanism? Looking at the DAO, I'm now reminded because of the DAO. Is this a rescue mechanism? Next week, I'm actually intending, I'm intending to say that this is something like Münchhausen, pulling yourself out of the swamp on your own hairs. But do you have another answer to that? Is that a solution in itself? It's a hype, isn't it? I mean, it's not really, sorry for that, but it's somebody's...
it's probably they will have inflation on this. People will probably, as before...
I assume nobody will buy it, because you need trust for a currency, you need trust.
You will still have a black market, people paying in dollars in Venezuela.
Possibly.
You cannot, in a way, I think, code away inflation. How would you do that?
Yeah, exactly.
Because you have to exchange for real assets, be it milk or something,
idea.
and that's not going to work. Yeah. I mean, that would be a very despotic system where everything, where you can enforce it. Maybe, we'll see.
Any further questions? Yes. Hold on, Oditha.
You were touching on the topic of property under German law, and that you were touching on the topic of property.
Yes.
under German law, and that this is quite vague here how to apply it. In the absence of precedent, what is your personal view with regard to, is it the private key in some wallet, is it the blockchain, or the conjunction of both? Where do you see it?
It's not clear whether, in a way, is the entry on a blockchain something you own? Is it your access details? Are those, in a way, the things of value? Marcos very early in an article proposed something and said there's no copyright in it, no intellectual property, because whatever these cryptocurrencies are, they have no original creativity in it. But maybe smart contracts have as software, so maybe there's no full answer that covers everything. Currently, I think it's a Gegenstand, like a thing, because under section 453 of the German Civil Code, the law for the sale of goods also applies to rights and other things, not things, other objects, but dematerialized objects. So it's kein körperlicher Gegenstand, it's not a tangible asset, it's an asset. So we can definitely deal with it under civil law and sell it and ascribe it to someone as an owner, but not in a way, maybe in the sense of physical ownership. I don't think that's probably not going to be a huge problem, really.
Exactly.
As long as you can know who owns it under law or under the factual circumstances, right? I mean you have one thing. You have trade secrets and know-how as well. I mean, that's not a new issue. That things that are not legally protected by any exclusionary rights are still of value and can be sold, right? Like the recipe for Coca-Cola.
No, it's really not as confusing if you're looking a little bit closer. That's what I'm telling my students constantly. We are dealing with virtual assets for thousands of years. I'm asking in this context my students always if they have ever seen a claim. The answer is, of course, no. It's just an imagination. The claim is something we then visualize it by saying it's something between us and Band, and a vinculum juris, something like that. I've never seen such a Band. I've never seen a vinculum juris. It is something which exists only in our minds. And so it's not too far away from something virtual like a Bitcoin.
It's the same with the idea that a company has a seat somewhere when it doesn't. The legal rationalists in the US call this transcendental nonsense, to assume that a company has a seat and is somewhere. It's not. It's nowhere. But we ascribe to it that maybe it helps us think about it and then deal with it. Okay.
The last question comes from Michael.
Does it work? Yeah. On precisely that point, I think it does matter to an extent when it comes to the location of the asset, because with the company, although but it still is registered somewhere in a particular register.
But not a claim.
A claim has a debtor. You can locate that debtor. He can move around, but you can get hold of him. But if you have a token that does not represent a claim or cash flow right, like Bitcoin, then, and that is stored on a distributed network everywhere, then it becomes difficult to say where is this asset, which is then also a problem when you have concurrent insolvency proceedings.
Right, it's like a euro coin. If you have a euro coin in the US, is this now subject to German law? Or it's the physical thing in the US probably subject to the late law there. So let's not think about this yet. Or maybe let's think about this, but not today. Yeah, but it's a good question. Yeah, but essentially, I think as courts always have to decide, they cannot not decide. We will probably have decisions sooner or later that we might like or not like, and then we'll deal with it. Okay.
That's a wonderful
sorry, that's a very trivial answer, but I'm sorry, that's how it is.
Now you spoiled it. And the other one would have been a wonderful last word for the conference. So, and for that reason, thank you so very much. Now we are at the end of the conference. Once again, thank you very much for coming here. And I hope you found it as stimulating as I am leaving this room again, enriched like hell. And I don't know if I'm wiser, but I have learned at least many things. Once again, I thank everybody who made the trouble to come here and to take the long, long way to come here. Some people came from Munich. I heard that you are the one. There is someone sitting, someone who's close to me. And You have a good weekend, nice weekend. Thank you again for having been here. And everything is going to turn out fine. Bye-bye.